In Elko, are you ready to proceed?
We are, Your Honor.
You may do so.
All right. Your Honors, striking down Section 4B and 5 would be a disastrous mistake. Section 5 of the Voting Rights Act is the biggest tool that the federal government has in its tool belt for fighting discrimination. It requires that districts, counties, or states with a history of serious violations of citizens' rights to vote are subject to preclearance. Preclearance is the pre-approval of changes to the voting laws in the state's subject. Section 4B goes hand in hand with Section 5, as it is the formula that provides Section 5B with all of the states that it must look over. Removing Section 4B is like chopping off the leg of the Voting Rights Act, because without it, the Act cannot stand. While there has been a large decrease in voter discrimination, it does not mean that it has disappeared entirely. Voter discrimination has moved from extremely visible policies to laws and provisions that quietly undermine the minority vote. Just because there is progress, it does not mean that you ought to remove the bill that has led to that progress. Just because a country is at a time of peace, they should not disarm their military forces. Getting rid of protections just because they are working is counterproductive and wrong. The Voting Rights Act is a crucial piece of federal protection of the fundamental right to vote. Every person in the United States ought to be able to vote for whom they choose and how they choose, regardless of the minority or majority opinion. To restrict this right in any way is to enact an egregious violation of the people's fundamental rights. If states or districts are the ones committing this violation, then it is the federal government's job to reprimand them. Your Honors, you may hear today that the formula outlined in Section 4B is outdated and therefore cannot be effective. The appellant will say that because the formula was written in 1965, that it can no longer be applied to modern-day America. If this was the case, then, by that logic, the Constitution would no longer be applicable to modern-day America, seeing as it was written in 1787.